We're going to listen as well. Jennifer's going to stay put, and we're going to head into the courtroom. Watching the trial with us today, former prosecutor Jason Friedman in New York with me, and out in Woburn, criminal defense attorney John LaChance. Gentlemen, let's take a listen. As you heard Jennifer report, this is an audio-taped conversation between this witness, the victim's wife, and the defendant, Sean Fitzpatrick.
Scene. They didn't find any of Mr. Fitzpatrick's fingerprints. They didn't find any of his DNA. There's no evidence, no physical evidence that the police found during their search of the crime scene that links Mr. Fitzpatrick to that crime scene.
So how about it, Jason? No direct evidence at all. Should a man spend the rest of his life in prison without any?
If the jury is persuaded beyond a reasonable doubt that he committed these homicides, absolutely. Of course, Jamie, every prosecutor would love to have plenty of direct evidence. How about a murder weapon with some DNA evidence on it?
How about that?
How about an eyewitness who actually saw the murders taking place? But we live in the real world, Jamie, and you know very frequently we don't have that kind of evidence, and that doesn't mean the prosecution can't prove their case beyond a reasonable doubt. Here, it's obviously a circumstantial case. However, I think that there is plenty of well-grounded circumstantial evidence that can persuade a jury that this man committed these homicides.
So you say a mountain of circumstantial. Yeah, and speaking of prosecution, let's bring Jason Friedman into the conversation. As a former prosecutor, I'm sure you found it difficult to make a case without motive, even though you knew full well that you didn't have to prove it. The judge would tell the jury that motive is not an element. But it's very hard to get your theory to hang together, isn't it? Especially in a murder trial without a motive.
No question about it, Jamie. And, you know, when you have overwhelming direct evidence, the motive, you know, can take a back seat. It doesn't become as important. And although technically it's not one of the elements that you need to prove in a prosecution, in a circumstantial case, the motive is very, very important because the jury is being asked to return murder charges, possibly send somebody away for life. They need to be comfortable in the absence of such direct testimony that they're doing the right thing. And motive can make them comfortable. Yeah,
I think without it, again, you don't have a full narrative, and sometimes the defense can give you a motive for some other theory of the case of the prosecuting. Obviously, and I'll come over to you, Jason, prosecutors and police followed the proper procedures, as we've just heard laid out by John, or else the call wouldn't come in. The judge would say, look, you violated someone's Fourth Amendment rights, this call is excluded. But here, they've gone through the proper channels. He's been talking to her for an hour. This call goes on for 2 hours. I can't even imagine talking to someone on the phone for that long. But of course, she's in the throes of grief. This is days after her husband has been murdered. He doesn't say a thing yet that is incriminating. Do you hear anything incriminating? You're a prosecutor.
No, and quite to the contrary. He sounds like a very caring individual, and he sounds like a close friend. What I think the prosecution is going to do here is try to establish that this was all part of the plan, Jamie, that he's freeing this woman from an unloving marriage, and then he's there to console her. You can almost sense during the course of the conversation that not only had they been close before, but they're almost getting closer as the conversation progresses, and I think they're going to try to argue that that was all part of the plan, and then obviously after the dust settles, he's going to swoop on in and continue the relationship with her. I might also point out, I think there were two secondary reasons that the prosecutor can use this. Number one, just in case he does express some type of statement that can be used to argue consciousness of guilt about what happened. And then the final thing, Jamie, would be based upon my understanding that the defendant is expected to testify, perhaps they can elicit some contradictory statements on direct testimony that flies in the face of anything he might have said in the recorded statement. And obviously the prosecutor would then use that to argue during summations to get a conviction.
Nothing a prosecutor likes better than an inconsistent statement, right, Jason?